If you do, please come up to the microphone so that everybody hears what you have to say. Anybody? Yes. Mrs. Sablan. I think that's the one.
Sure. Good evening. I do have a question. I'm a member of the DB plan, defined benefit, and my question tonight is, we have not gotten anywhere in regards to our retirement withdrawal, right? And everything is on hold right now for those who have submitted to withdrawal. My question behind it is that if you are less than 15 years of service, you're able to get your money, right? So the difference there is why? Why, that there are some that can get their money for 14 years, and then us who are vested in for more than 15 years, we can't get our money back. Secondly, the reason why, on my behalf or myself, is that I submit in to withdraw knowingly, based on all the media and all the newspaper, that the retirement will be out of funds by March 2014, in which that is my retirement so-called date to retire. Now not being allowed to get my money back, and yet I have submitted that in already. I have been seized already in the retirement payment. And to get back in again, you know what I mean? I could have been earning or being paid in until such time that a decision has been made, whether to get it back or to go ahead and continue. So all those are the things, and I'm a vested member as well already with the Social Security, see? So those are what I'm looking at. And on the other hand, what if, for example, I die tomorrow? Would there any benefit for my little girl as a member, or so-called member then that I withdrew, that I have not gotten my money? Those are things that, puts in place as to where we stand. And if we are allowed, like on myself, if I'm allowed to go back in again and just be contributing both so-called Social Security and retirement, and still be earning that until such time a decision is made. We all were just mentioning that it might change the date of the funds that it will be out of money if the government had provided in or make that promissory commitment to pay, right? So in my stand, then therefore that would give me an opportunity to continue on and maybe to retire. So those are the questions that I'm asking right now. Where do we stand as a DB member, Because when all the media was out and all the applications, you have all these deadlines to meet, and you have only 2 weeks to cancel it, knowingly that some had already gotten their share of that 25% in the initiation at the beginning, and then all of a sudden everything is at all. So where does that leave us? Thank you.
Thank you, Bobbie. First of all, let me answer your first question about employees who have less than 15 years being able to take their money out. That is not true. If you are, the only time you can refund your contributions when you fall under the 15-year benefit service with the government is when you separate employment with the government. Okay, you have to quit. Now with 1782 and 1802, it does not require you to terminate your employment, but still be able to take out, withdraw your contributions. So you don't necessarily, or employees with less than 15 years are not able to take out their contributions unless they terminate their employment.
It's my understanding, 1782, been allowed for
without proving that. Am I mistaken?
No, that's not correct.
And what exactly, where do you get this? You're not getting it out of 1782 or 1882.
Yes. Oh, I'm sorry. I misunderstood your question. So yes, 1782 would allow you to take your money out, but because everything has been on hold, all disbursements have been on hold, the only time employees who can immediately avail of their contributions is if they separate from government and have less than 15 years of service. Because right now, there have not been any disbursements since the first batch, which happened in October.
So the public laws are not, somehow they're on hold.
Yes,
Yeah, that's correct. I mean, what you're talking about, the public law 1782 and the 1882, that's correct. Those laws basically, during the April 2nd hearing, when the governor was under cross-examination, he agreed to basically not implement that law or not enforce that law until the settlement procedure had gone through its full fruition. So that is my understanding, is that the law will not be enforced until the settlement is over. Now the court has ordered the parties to address Public Law 1782 in the settlement. So there will be, by order of the court, a resolution of that Public Law 1782 issue within the context of the settlement. If there is no settlement, as I told you before, the court is going to have take on all motions, including the Public Law 1782 motion, July 8th and 15th, and the hearing will be held on August 5th and 6th. And so basically you'll have your answer, the first week of August, we anticipate from the court.
So regardless of the local laws, you are unable to tell us that we would be able to withdraw our contributions if ever.
Well, that's sort of a loaded question. I mean, the court is going to make a determination on what's going to happen with Public Law 1782. I mean, what I can tell you is, and maybe this is what your question is asking, so I'm guessing, but you tell me if it's not answering the question. I think the plaintiff in this case has made it very clear that they will be challenging Public Law 1782, and that they will take the position that Public Law 1782 is unconstitutional, that Judge Govendo's order was illegal, and they will try to convince the court that Public Law 1782 should not go forward. And if they're successful in that, then this separation of you have these two separate tranches. One is tranche A for the actives, and of course that money is basically invested, not touched, not drawn down, and is not used at all to pay any pension benefits. That's tranche A. And then you have tranche B, which is the active fund paying the benefits. And so if the plaintiff was successful, I would guess that those two tranches would merge, and there would be no more opportunity to get your money. That's my understanding of the process and procedure right now.
Okay, so you are saying that it's under active consideration that the monies that people that place as active government employees that placed in their retirement accounts by law, not on any fund, is going to be taken to pay other people's retirement benefits. Is that what you're telling me?
I'm not the judge, so I don't know what the judge will do, but those, I believe, are the anticipated motions, and those are the anticipated issues. How those issues come out, I don't know. The briefing will be done by the plaintiff on July 8th, and I mean, what I can do is take the plaintiff's brief on the retirement fund website, you can read the plaintiff's arguments. It's out of my control. It's not something that myself or the fund, it's between the plaintiff and the court. I assume the government will file some motion or some opposition. I don't know what the government and the plaintiff have.
I can just elaborate and confirm that the government does believe that they're validly enacted laws and that people who elected to withdraw should be able to withdraw. And if plaintiff does in fact file a motion to the contrary, the government will strongly oppose that. We believe that the DB members should be able to withdraw if they elect to withdraw pursuant to Public Law 1782 and 1802. And also maybe just to clarify something that Mr. Rosano said, the court had ordered the trustee of litem to not disperse funds pursuant to 1782 and 1802, but to have the parties work together to continue processing what is owed. And the government has been doing that on our end. I think we are trying to work that out.
Thank you.
You're welcome.